Hello, my name is Robert Curigliano. I work for My Arizona Lawyers, and I primarily handle criminal defense matters. If you'd like a consultation with our office, please feel free to reach out to us at 480-833-8000. We will be discussing expungements here in Arizona for the purposes of this video. Expungements, quite frankly, in Arizona do not exist. You cannot have a record be expunged in Arizona. Expungements do not happen. However, in Arizona, you can do or you can file what is called a motion to set aside. A motion to set aside basically sets aside the guilty either verdict, guilty plea, or whatever the circumstance may be. This is important for various reasons. For one thing, if it is a felony conviction, frequently felony convictions carry with them constitutional implications. They may have affected your ability to vote. They may have affected your ability to own a firearm. Whenever filing a motion to set aside, we can typically attempt, at the very least, to have these reinstated in conjunction with a motion to set aside. For the purposes of a misdemeanor matter, you can also file a motion to set aside, and it would no longer list your case as having been a conviction or a plea, but it would list your case having been set aside. The procedure by which motions to set aside occur are kind of a twofold process. If your case involved any level of confinement associated with the Department of Corrections, we would first need to request an absolute discharge. In the circumstance that it is a first-time criminal conviction, you can basically immediately, in felony cases or in misdemeanor cases, first time, request a motion to set aside. In situations where it's 2 felonies or more, you do have to wait the requisite period in order to file a motion to set aside. But the first step is to request the absolute discharge. The absolute discharge basically is information from the Department of Corrections, which lets the court know that you have complied with every portion of either your sentence, probation, you have completed your sentence in every possible way. Once we receive that documentation, we would draft and file a motion. This motion would basically spell out why we believe a motion to set aside would be appropriate in your case, and we would file that with the court. At that time, the state, be it the prosecutor who had originally worked on your case or the prosecutor who is now assigned to your case, would have an opportunity to respond. In certain circumstances, prosecutors respond and state that they object to the motion to set aside, that they do not feel that it is appropriate. In certain circumstances, prosecutors have no problem with it. At that point, typically, it moves forward and is granted. Other circumstances, sometimes prosecutors, quite frankly, do not respond at all. If that's the case, typically those motions to set aside are typically granted. With that being said, the prosecutor can also request a hearing. The hearing will give us an opportunity to present your side of the matter in order for a judge to better understand your story, and that would also give the prosecutor an opportunity to address why they feel the case should not be set aside, why the conviction should be upheld. At that point, the judge would make the final determination as to whether the motion to set aside is granted, and should it be granted, it would no longer show a criminal conviction on your case. However, it would show that the case was set aside. Thank you.